Good morning, everybody, and welcome to our presentation on what is now the Renters' Rights Bill. So you may remember this as the Rental Reform Bill, which is what it was previously named under the previous government. Obviously, that government didn't get the bill through in time, and so the new government has now rebranded this as the Renters' Rights Bill and added numerous changes to it, which is what we're going to run through today. As a landlord, obviously, it's really important that you're keeping up to date with these items. They have a massive impact on your tenancies and how you deal with your tenants. So we're going to try and cover off as many of the changes today as we can. The reason we've done this as a presentation is so that obviously you can go back and re-listen to it at certain points if you need to make notes. But also we're expecting a large amount of questions based on the content. And so we're going to tell you at the end what you can do with those questions and how you get in touch with us. What I would say is obviously none of the things we're going to discuss today are actually law yet. To some degree, it is business as usual. Until these changes actually come into law, none of this affects your tenancies as of today. We are recording this on the 24th of October, so depending on when you're listening to this, there may be some changes. However, we will issue updates as and when we receive them from the government. So in terms of where we are now, so as I've said, the new government have reintroduced the bill, and it's now gone through its second reading in Parliament, which is why we're issuing this presentation, because we seem to have ironed out most of the creases, and there's now a strong idea as to what the Labour government are going to bring forward as an actual bill. The next stage is it goes to Select Committee, then the House of Lords, then it gets Royal Assent. And normally that's quite a long process. However, this bill does have cross-party support and there is big momentum in the bill at the moment. It is expected to happen very, very quickly, and there's speculation that the Royal Assent could be done as soon as January because they're not expecting too many amendments from the committees in the House of Lords. And there's further speculation that this will actually be law for next summer. So what's going to actually happen? So there'll be a date when the bill becomes law, and when that happens, they will also set a commencement date. Now, that's the date that the law actually starts, and it's normally a good gap between the bill becoming law and the commencement date to allow the market to prepare, allow you to deal with any paperwork that needs to be done, and to put the necessary procedures in place. Now, one of the big differences between what the Labour government are proposing and the previous government is that the previous bill was going to allow for a transition period where if you were on an old style tenancy, you could continue to run that until your tenant left, and then any new tenant would have to commence on a new style tenancy. That has now been scrapped, and the new government are proposing more of a big bang approach where overnight all tenancies will come under the new bill. So regardless of the tenancy agreement you have in place with a tenant, it will automatically come under the new law based on the date the government set. Now, what that means is any fixed term you might have with a tenant, 6 months, 12 months, will automatically become null and void because all tenancies will go onto a periodic tenancy, i.e. a monthly contract, which we'll come on to in a second. And because of this, we're now advising landlords not to renew any tenancies with tenants, primarily because it will be a waste of time and money for all parties, because a 12-month tenancy signed now will probably be null and void by May, June next year, depending on where the bill commences. Now, in saying that, the sceptical side of me feels that you might see a big push from agents to renew tenancies because they're going to be losing an important revenue stream. However, we would advise landlords at this point that paying for a renewal is completely pointless. So one of the key parts of the Renters' Rights Bill is that all tenancies moving forward will become periodic from day one, i.e. there'll be a rolling monthly contract. You can no longer tie a tenant into a fixed term of 6, 12, 18 months. Again, just to confirm, this will happen overnight from the day the bill becomes law. So regardless of any fixed term your tenant size, the date the bill becomes law, you will automatically go onto a monthly contract. Now what that means is tenants can give 2 months notice from day one. So they can move into a property on the 1st of August. On the 2nd of August, they can give 2 months notice to vacate. And there is nothing that the landlord will be able to do. The landlord will be able to use various different notices to end the tenancy. And All notices will become what's called Section 8 notices, which we'll come on to shortly. But there'll be different timescales for landlords to be able to issue those to the tenants. So for example, you won't be able to issue a Section 8 for rent arrears during the first 6 months of the tenancy, and you won't be able to issue a Section 1 notice, i.e. you want to sell the property, for the first 12 months. Now, one of the key concerns of this for landlords is there could be potentially a high turnover of tenancies. You might get a number of tenants trying to use properties as almost like an Airbnb for short-term lets, just moving in for a month, etc. Or 2 months, should I say, and using properties as a stopgap. Now, we'll come on later to how you can avoid those issues and why we don't think it's a particular concern for most landlords. One of the big issues with this process is it's going to be a bit of an administrative nightmare, to say the least. So there's a strong chance the day the bill becomes law and all your tenants move on to a periodic tenancy, then you're going to have to reissue how to rent guides. You're going to potentially have to issue a tenancy addendum to inform tenants of their new notice rights and explain that they're no longer in a fixed term. However, the benefit to using a good agent is obviously all of that should be done for you and should all be documented and noted on file. We are still awaiting guidance on exactly what will need to be done. And obviously, as we get nearer and nearer to the bill becoming law, I'm sure we'll be issuing further guidance to landlords on that as well. The other major issue with the removal of fixed terms is how you deal with advance rent. So effectively what happens under a periodic tenancy is the only rent period available to anybody will be a 1 month period. And the new bill outlaws taking advance rent from tenants. So essentially you only be able to take payment for one rent period, which is 1 month. So you will no longer be able to take rent in advance of say 6 or 12 months. Obviously, that creates big issues for certain sectors of the rental market. For example, students, people moving over from overseas, people with adverse credit, where normally the way around being able to credit check reference was to take 6 or 12 months payments up front, and that would basically satisfy the fixed term of the tenancy and would enable you to ask them to leave at the end of that if you weren't able to continue. However, that option has now been lost. Under the previous bill with the Conservatives, there was an option for tenants to be in credit. So effectively, while you couldn't enforce that tenants would have to pay 6 or 12 months up front, it did allow for the tenants to be in credit. So if they volunteered the money, you could hold the money as credit, and basically that would prevent an advance rental payment. However, it doesn't look like the new bill is going to allow that. The other issue this means is that once the date of implementation is given, any rent you have taken in advance, there's a strong chance you will have to refund it to your tenant. So if on the 1st of May, you take 6 months rent in advance from a tenant, and the bill becomes law on the 1st of June, you will have to refund that 5 months you've taken up front back to the tenant to make sure you don't fall foul of the law. The other big concern for landlords under the new bill is the removal of Section 21. So if you're not aware, Section 21 is what is commonly known as a no-fault eviction. So while you're in a periodic tenancy, you can give a tenant 2 months notice asking them to leave the property. You don't have to give any reason at all for asking for your property back. Now, the previous bill again referred to court reform having to be implemented before Section 21 was going to be removed completely. However, the new bill proposed does not give any mention at all to court reform, and there's been no reference to it. During the second hearing, Angela Rayner talked about digitisation of the court system, but there was no mention at all of it being linked to the bill and that it would be a necessity in order to bring the bill forward. So the moment the bill becomes law, you will no longer be able to serve a Section 21 on your tenant. So all evictions or all possession cases will have to come under what's called Section 8, which is most commonly known for using it for rent arrears. However, Section 8 does have a myriad of different grounds which you can use to request your property back from a tenant, and you'll have to document what that new ground is and the reason you want your property back. Now, the key issue to this is that all Section 8s require a hearing with a judge. So under Section 21, you were able to use what's called an advanced possession procedure, which meant as long as your paperwork was correct and the tenant didn't try and make a defence because you haven't maintained the property, the judge would automatically give possession without the need for a hearing. Under Section 8, unfortunately, that is not the case. So Section 8 always requires a court hearing. This could potentially mean you need a solicitor. It makes the paperwork more complicated. And of course, the moment you're in front of a judge, you are opening yourself up to the human element of a case. Tenants give the opportunity or are given the opportunity to plead their defence, to say, well, they should be allowed to remain in the property. And of course, it makes it more of a challenge for the landlord to get their property back. But one of the key issues for this is that the fact that the courts will become a lot busier with the removal of Section 21. Depending on where you are in the country at the moment, it's already potluck as to how long it will take to get a court date if you're using an eviction procedure under Section 8. For example, Birkenhead is very, very quick. You can get a court date there within sort of 6 to 8 weeks, whereas you go to Manchester and it could be 4 to 5 months. So it is very much potluck where you are in the country. And there's no doubt that the courts will get a lot busier once Section 21 is removed and all tenancy possessions have to go in front of a judge. Now, under the removal of Section 21 and Section 8, as I mentioned, there will be new grounds introduced. So if you want to sell your property, you can use that as a reason for possession. However, you need to be aware there will be enforcement grounds if you're not using the correct possession grounds. So if you give a tenant a notice saying that you want them to leave because you're going to sell the property, and then you put the property back on the market to let within 12 months of them leaving that property, you could potentially be fined £30,000 for the incorrect use of an eviction ground. So if you're looking to sell your property, essentially you have a 12-month grace period whereby if you put the house on the market, you'll have a 12-month period whereby you can attempt to sell the property. If you don't sell within the 12 months, you'll then be allowed to re-let the property. However, if you try and re-let within the first 12 months, the previous tenant could claim that you evicted them unlawfully and be able to report you to the council, who can then enforce the £30,000 fine. I've had lots of landlords ask me if they can just serve a Section 21 before the bill, and then it would still be valid. It absolutely would still be valid. However, you need to be aware that currently Section 21s already have a 6-month rule. So if you serve a Section 21 and give a tenant 2 months notice, you have to act on that notice 4 months after the end date. So essentially from the date you serve the notice, you've got 6 months to serve papers to the court. You can't leave a Section 21 in place without any end dates. It can't be there for life, basically. Now, when the new law comes in, that 6 months will be reduced to 3 months. So if you serve a Section 21 just before the new law comes in, you will only have a 3-month period in which to effect that Section 21 and take the paperwork to the court. There are some changes as well to rent arrears under the bill. So currently, if you're trying to remove a tenant for rent arrears under Section 8, the tenant has to be 2 months in arrears and you can give them 2 weeks notice. It's looking like that could well be extended to 3 months in arrears and you would have to give 4 weeks notice. So essentially, the tenant could get to 4 months in arrears before you're able to start court proceedings. However, under the new rules, it does look like there is going to be better legislation to catch repeat offenders on this. So if you're unlucky enough at the moment to have a tenant who tries to play the system, so for example, they constantly go into 8 weeks arrears and then make a small payment to bring them under, knowing full well that it means you can't go to court, that will be wiped out under the new system. So tenants who repeatedly go into 3 months arrears, and the previous bill said it was 3 occasions within 12 months, but the guidelines on this are not quite clear yet on the new bill. However, if you've got a tenant who does constantly go into arrears, it will be much easier to evict them and they won't be able to play the system like they can under the current Section 8 rules. Although a lot of that sounds like a bit of a nightmare for landlords, I should really point out that, first of all, 80% of tenancies in the UK are ended by the tenant rather than the landlord. So this does affect a very small amount of cases. Also, very few cases do go to court. These things only become an issue if the tenant doesn't leave at the end of the notice period that you've given them. And most tenants generally, certainly under the current Section 21 rules, once you've served notice, they will attempt to leave the property and try and find a new property to go to. And from the legislation that we've seen so far, the new grounds for selling the property could actually make getting possession back easier than attempting a Section 21 under the current rules. You should bear in mind, though, that the tenant will still have the defence option for a lack of maintenance. So if you are trying to evict a tenant because they've reported a boiler's not working, or they're a tenant who's particularly pernicious about maintenance within the property, then you would not want to attempt an eviction procedure, simply because the tenant will still be able to use a lack of maintenance or the fact it's a revenge eviction as a defence in court. Now, I know some landlords have already raised the question about the student market, because a lot of these things that have been brought into place are a major issue for student tenancies. The reason being, removing fixed terms means that students could potentially leave mid-term and leave you with void periods, because it's really difficult to find student tenants midway through the student year. You're also going to be unable to take payment up front, and most student lets are based on 6 or 12 months up front, or at least paying for a term up front, because most of the students aren't working, obviously, so you can't rely on income to pay the rent as such. And you also won't be able to serve a Section 21 2 months from the end of the fixed term to ensure that they leave the property and you can move the new student tenants in for the next year. So there's quite a few issues here for student landlords. However, there is still a number of ways around this. So first of all, you will absolutely still be able to ask for guarantors, and you can make that mandatory. There's no discrimination rules about asking for guarantors. So that could deal with the issue about taking payment up front if you've got parent guarantors, which we would always take on a student tenancy. And they are looking at bringing in what's called a prior notice ground before the bill. Essentially what that would do, before the student signed a tenancy, you would give them prior notice that during the tenancy you are intending to use an eviction ground. It's quite complicated, this, and the wording is still to be drafted. But essentially what you would do at the point of issuing the AST to the student, you would give them an addendum that says, look, in 10 months' time, there is a good chance I'll be serving you some sort of notice. We're not sure of the grounds yet. However, you need to be aware this could happen. And then that potentially could be a way around being able to bring the tenancy to an end during the correct student market. Rent increases. So moving forward, there is only going to be one way in which you can increase the rent with the tenant. Now, the good news is, the way that the government want you to do it is the way that we've always done it at Infinite, or certainly for the last 4 to 5 years. So as a landlord of Infinite, you probably won't notice any difference here at all. The way that it's got to be done moving forward is you have to use what's called a consultative approach via a Section 13 notice. This is a notice issued to the tenant to state that on the particular date, their rent is going to increase. And most importantly, along with that notice, the tenant gets issued certain guidelines about what they can do if they're unhappy with that rent increase. Now, that's always been the case. Section 13 has been around for years and years. So none of this is new. However, it's now become mandatory. This is the only way you can increase rent. So any tenancies you have which have pre-stated rent increases, so anything saying it's going to go up by 3% per year every year, will become null and void. You will no longer be able to enforce those rent increases. You'll only be able to serve Section 13 once in any 12-month period, which is the current rules. So annually, you'll be able to issue a rent increase to the tenant. And moving forward, you will have to give the tenant 2 months' notice rather than the current 1. So the way it works at the moment is you have to give them 1 month's notice, but it's based on the rent payment date. So if they pay on the 1st of every month, you could issue a rent increase notice today on the 24th of October, but that would not affect the payment on the 1st of November. The rent increase would take place on the 1st of December. So you're giving them 1 month's clear notice, 1 rent period notice. Moving forward, when the bill becomes law, that will change to 2 months. So if you serve the notice today on the 24th of October, the increased payment would take place on the 1st of January. Now, the tenant, as I've said, will have the opportunity to refer a rent increase to a tribunal. That's already in place. Nothing there has changed. However, one of the big issues is that with the removal of Section 21, the tenants might be more inclined to take a rent increase to a tribunal because they don't fear a potential revenge eviction or a no-fault eviction because they know Section 21 has been removed. And one of the key issues with the new bill is that the way tribunals work at the moment, if the tenant goes to a tribunal regarding the rent increase and the tribunal finds in favour of the landlord, then they will backdate the rent increase to the date the notice was served. But also the tribunal has the ability to actually increase the rent. Now, I've never seen this, but the way the law is written currently, if a tribunal feels that the rent increase the landlord's issue is more than fair and the tenant is frivolously disputing it, they can actually increase the rent that the landlord's asked for up to market value. As I've said, I've never seen it, and in 20 years I've not had one case go to tribunal regarding the rent increase. However, the new bill means that the tribunal will not be able to rule to increase rent. The maximum the tribunal will be able to give is the increase that the landlord has asked for. But most importantly, they will no longer be able to backdate that rent increase. So the increase will only start from the date the tribunal finds in favour of the landlord. Now, if there is a large amount of rent increases disputed by tenants, you could find the same issues as we have with the court, where the tribunal cases take longer and longer to hear. The tribunal system is not really cut out for large amounts of cases. It doesn't really get large amount of cases now. So you may find that it could take a much longer time to get a tribunal heard, and therefore that rent increase will take much longer to come into force. However, the key here is kind of what the government are driving at, in that they want this consultative approach. So before you serve a Section 13, the idea would be that you would speak to your tenant, or your agent would speak to your tenant on your behalf, present the evidence why you feel the rent you're requesting is fair. It can't just be due to inflation, unfortunately. That's all going out the window. It must be linked to a market rent. So you must have evidence that properties similar have rented for the rent you're proposing. And you can't just say my mortgage payment's gone up. You can't just say the inflation, every cost of everything are going up. That is all irrelevant. They're purely looking at market evidence. So you present that to the tenant and explain why you feel the new rent is fair. And before you issue the section notice, any potential argument should be gotten out of the way. So you don't want to issue a rental notice that tells the tenant how they can go to a tribunal before you've had that conversation with them and you know they're going to accept the rent increase. The other thing that's come under the new bill is the removal of bidding wars. So under the new law, you will not be able to create an AST for more than the advertised price of the property. So for example, if we market a property on Rightmove for £800 and we have 10 tenants who want it, we will not be able to go to those tenants and say, okay, Mr. and Mrs. Smith also want this property, they've offered 825, are you willing to go to 850? We will no longer be able to do that. An AST can only be created at the advertised price. Regardless of interest level, it doesn't matter what evidence you can provide, you will not be able to charge more for the property than you've advertised the property for. Pets is a big issue that's been in the news for various different reasons. Under the new bill, you will not be able to decline a tenant on the basis they have a pet unless you have good reason. You will, however, be able to insist on taking out insurance against pet damage, and the tenant has to take that out and pay for it. Exactly how that's going to be enforced, we're not sure yet. The reason being these policies don't even exist at the moment, so we're waiting on guidance again about who's going to produce those policies, what the wording is on them, and what those policies will look like, what sort of cost is going to be involved. So until that happens, these insurance policies are a bit of a myth. Existing tenants can also request permission and you cannot unreasonably decline, and we're expecting this to be the bigger problem, to be honest with you. The reason being, when you're advertising the property, assuming the marketing's right and the pricing's right, you generally have the choice of 3 or 4 different tenants who want to take the property. So at that point, if you wanted to avoid a tenant with a pet, you will be able to do so on the basis that you just decided to select an alternative applicant. However, once a tenant's in a property, it does take that argument away. So you will have to have a good reason in order to decline a tenant from taking a pet once they're inside your property. Now, we haven't been given any guidelines yet on what is reasonable, and we're expecting more information to come out. But some examples could be dogs in communal areas. So any property that has some sort of communal space, you could easily argue that dogs are not allowed because there might be somebody else who shares that communal space who could have allergies. They might be scared of dogs, etc. Just quite easy to argue that away. If you have apartments, most apartment leases will state that you can't have pets in the building. Again, coming back to that communal space, not fair on the other residents. So if you do have apartments, you should strongly start checking your leases and seeing what the wording is. And then anything that we would deem as unreasonable. So for example, if you wanted 4 donkeys in a 2-bed terrace, I don't think anybody would expect you to have to accept that as a landlord, and that would be deemed unreasonable. With regards to current tenants, who already live in the property, you would have the same, obviously, reasons on what is reasonable. But also, if they were to request a pet 2 days after moving in, I think you could argue as a landlord that again would be an unreasonable request, given that they presented themselves as a tenant without a pet, and then 2 days later they're asking if they can have a dog or a cat. I think you could argue that as a reasonable excuse to not allow a pet within the property. However, that's still to be given guidance on. As well as pets, there's going to be various other rules coming in on discrimination. Now, again, most of this, if you've got a good agent, they'll already be using this as common sense. So you won't be able to advertise a property with things like no children, no housing benefit. If you are advertising properties like that now, you need to take a more common sense approach, because there's already discrimination rules in place which you could fall foul of if you are using statements like this in your property advertising. You will be able to insist on no overcrowding. So, for example, if you have a couple with 3 children who are looking to rent a 1-bed apartment, of course you can say, no, that's not suitable. But you won't be able to take a blanket approach to no children in my property. All of this, though, comes down to strong rental demand. So as long as you've got a strong rental demand for your property, you will always have a choice of tenants to choose from. And it comes down to that common sense approach, looking at realistically who is the best tenant for your property. And as we're going to talk about in some of the later slides, that's going to be more important than ever moving forward. So moving on to EPCs, or energy performance certificates. Now, this is not actually part of the bill, but it's expected to be confirmed very shortly, that by 2030, all rental properties must meet a level C under the energy performance certificate. Okay. Now, we have been here a couple of times before, and it's constantly been scrapped or put back. However, we now have a government who are very committed to net zero, and I find it really unlikely that this particular deadline is going to be scrapped or amended. There is a few things you need to be aware of, though. For example, there will be a cap still on what landlords should be expected to spend. That cap hasn't been announced, but on every previous time they've tried to bring this into force, there was a cap on what they would expect landlords to spend on their property to bring it up to level C. So if you have a particularly challenging property, grade 1 listed, for example, where it's very, very difficult to make amendments, or amendments are very expensive, you will be able to show that you've spent the maximum the government require, and you're still not brought to a level C, but you will receive an exemption under that. Okay. What I would advise landlords to do straight away is go away and check your EPCs on your properties now. Look at what has been assumed on EPCs. We see lots of EPCs where it's assumed there's no loft insulation because they couldn't get into the loft on the day. However, things like that you need to be more stringent on now. You need to make sure that your properties are being checked thoroughly, and look at what areas can be improved. Number of properties can go from a D to a C relatively quickly by a bit of extra loft insulation, some energy efficient light bulbs, and you'll be amazed how many additional points that can give you. And you need to start looking at those things sooner rather than later. Now, EPCs last for 10 years, and the thing with EPCs, they're not like gas certificates and the electric certificates, so they don't have to be renewed unless you're marketing the property. So you could have an EPC that's 8 years old on one of your properties, and you might have spent some money on the property over the last 4 or 5 years, new boilers, some additional insulation, and it may be that EPC is outdated, and if you were to get the property reassessed today, it would improve its value, and you could certainly look at getting that new EPC done relatively quickly. They're fairly inexpensive, about £85 from memory, but if it means that you can have an EPC now with a level C rather than waiting until 2027, I would suggest you look at doing that as soon as possible. You can also look into what grants are available and try to prepare as much as possible. There are various grant schemes that we've seen that would allow you to make various amendments to the properties, so air source heat pumps, internal insulation, solar panels, etc. We are looking into this as a company at Infinite. However, what I would say is we've had a pretty bad experience with the grants we've looked at so far and the quality of the installers. And so until we can see some improvement in that area, we are a bit reluctant to start recommending companies to landlord. It is very dependent on your tenant as well. So there's not really any grants available just for landlords to go and improve their property. It does very much depend on the tenant status and it's almost effectively the tenant who can apply for the grant depending on their work position, their age, etc. However, my advice would be to start looking into now what might be available. If there's things you can do to improve your energy efficiency that don't cost you a substantial amount of money at this point, it'd be better to do it now rather than later. By the time we get to 2029, there is going to be a serious lack of tradespeople available, a serious lack of materials to start doing some of these works. So you want to be well ahead of the game. There will still be some exemptions, to EPC. So, for example, grade 1 listed, currently you don't need an EPC if you want to rent or sell. Those will still be exempt as far as we're aware. And I've already talked about the fact that there will be a cap on what landlords are expected to spend under the new scheme. Apartments are a lot more difficult. Obviously, you don't control the building, and it's very difficult for you to touch the fabric of the building under the terms of the lease. That makes it generally very difficult to potentially add things like cavity insulation. You can't insulate between the floors and the ceilings because you don't have access to those areas. They don't technically belong to your property. Even changing windows to double glazing can be really difficult. Again, it comes back to getting hold of your lease, find out now what is your responsibility, what's the responsibility of the building owner, and working out what things you can do to try and improve the energy efficiency of your property. Well, hopefully that hasn't depressed everybody too much. It is very much a changing landscape at the moment, and you shouldn't see it all as bad. With every change comes opportunity, and the key to all of this is knowing what the new rules are going to be and preparing yourself so you're ahead of the game. There'll be lots of landlords and lots of agents who are not on top of this and don't understand the incoming rules, and you want to be well ahead of those to make sure that your tenants and you are in the best position to adapt to anything that might be coming. There are a few things that you can do though moving forward, and when I say moving forward, I mean once this bill becomes law. So we're already looking at different ways in which you can protect yourself as a landlord, so you don't fall foul of some of these new laws. So the first thing is, and this is probably key already to be honest with you, but even more important in moving forward is to know your tenant. So given that tenants can now move in and give 2 months notice, letting to the right person will be even more key moving forward than it is currently. So it's not just going to be about, can they afford the property? Is their credit history good? We're going to need a lot more information than that. And we're going to need to look at people's personal circumstances a lot more. So what is their connection to the area? How long have they been in their job? Do they work local to where the property is going to be? Are they working from home? Does the new property provide an office for them? Will they outgrow it very quickly? Do they have family in the area? Have they got a local tie to the area? Or more importantly, if they've got children in local schools, which tends to give you a much longer term tenant, because moving schools is a big decision and moving home when you've got children is a big decision. So the key moving forward is to know your tenant. It's not just about referencing anymore. There'll be a much more human aspect to it. What are the reasons this person wants to rent this property? What can we find out about them? And do they look like the sort of tenant who is going to stay much longer term rather than someone who's just going to use it as a stopgap? Guarantors. So you may want to go down the route of insisting all tenants have guarantors moving forward, because obviously the potential for rent arrears to accrue, longer court cases. The guarantors will give you an additional level of protection. However, we find that guarantors are only worthwhile under certain circumstances. And the problem with guarantors is if you insist on guarantors, you may well be limiting your rental market. There are lots of people who are very good tenants who don't have the ability to get guarantors for various different reasons. So the minute you say, I only want tenants with guarantors, you will be limiting your tenant pool slightly. But you should only take a guarantor, first of all, if it's a family member. We would insist on it being parent, brother, sister. We don't really want people to use bosses, friends. The reason being, with a guarantor, you need that embarrassment factor in order to be able to enforce it. Most people won't allow their parents to be guarantor or brothers and sisters, and then let them get into financial trouble. However, friends fall out, people leave jobs, so bosses are no longer close to them. So if you're going to take a guarantor, again, you need to work out why that guarantor is in place. Will that guarantor be able to pay the money, most importantly? So can they meet the affordability and the credit criteria? But also, what is the relationship between these two people? Is there going to be that embarrassment factor whereby if the rent's not paid and we go to the guarantor, either the tenant or the guarantor will be willing to make the payment? But the other easiest way to protect yourself against all this is to insure your income. So rent protection policies are going to be even more valuable moving forward. We have a particularly good one here at Infinite, which has a 100% claims record. And given the length of court that potentially court case is going to take, this could be particularly valuable moving forward. The reason being, the way the policy works is you will receive 100% of the monthly rent until you have possession back of the property, and there is no cap on the number of months. So lots of policies will end after 12 months, for example. The policy that we use, there is no cap on it at all. So if the courts do become particularly busy and you have a particularly horrendous case that might take 2 years to get a tenant out, I've never come across that, but let's not rule anything out, then you will receive 100% of your rent for that 2-year period until you receive the keys back. All your legal expenses are covered. So if you ever had to evict a tenant before, you'll know it is very expensive. And given the fact that every eviction now is going to need a hearing, which will potentially involve you having to appoint a solicitor to go to court, then your legal expenses are going to rack up fairly quickly. The policy will recover any rent on your behalf, and it also has the property damage cover. So any damages over £1,000 which exceed the deposit level, they will pursue a civil dispute for you to receive that money back from the tenant. Now, once you've got possession back, you will get 75% of the rent for a further 2 months to allow you to get the property back on the market, carry out any works that need doing, and bring it up to a rentable standard. There's lots of other things that the policy includes. If you're not aware, feel free to email us. We can talk you through the policy, what the cost would be, and what the policy can do for you. So the key thing now is what happens next. Well, as you know, the next step is it's going to the select committee, and there will, I'm sure, be various updates following that procedure. So keep your eye out for updates from us. Keep your eye on your emails, our socials, which is where we'll post most things. Any major updates, we're likely to issue a new update similar to this in a presentation style. However, there might be some minor changes which are introduced where we'll just send them out via email or on the social networks. If you do have any questions, and I'm sure you have, feel free to email Darren at Infinite Property. If you put subject renter reform in the inbox, just so we can track the number of questions that are coming through. We don't have the answers to everything. However, what we don't have, we will try and go away and find out for you, and we'll certainly try and help as much as possible. As I've said, please do be aware, though, that none of what we've talked about today is law yet. And to all intents and purposes, it is very much business as usual at the moment. But probably the most important thing you can do is start reviewing your portfolio. Look at your EPCs, look at your leases, find out what you can and can't do, and most importantly, know exactly what your position is as a landlord from a legal point of view. Can you refuse pets? Is there things you can do to improve your EPC rating fairly quickly and cheaply? And just to keep an eye on everything within your portfolio as much as possible. Hope that's been informative. As I've said, feel free to email us with any questions that you have, and we'll speak to you soon.